I know PP will say that we are doing the work of the investigators, but he is a good investigator who got a bit overwhelmed by the volume of evidence. Can you scroll down? Once again, our sincere apologies, and on a lighter note, the blood of HASD is on the top of the layer of our skin, so we are hoping that based on our overall performance and efforts, Public Protector will forgive us and the whipping stick can remain under the PP's table until Monday.
Correct. And the PP's response then appears at 3993. So at the bottom. 3993, yeah? Yeah, at the bottom, yeah. Go down, yeah, that one. Yeah, there. She says, and you're going to go down to 3994. She says, good morning, Ms. Mogaladi and team. HASD to focus on the conduct of officials of COT, the evidence we have acquired from COT, and not to use affidavits or reports from other sources. Always remember the PP report is meant to address the root cause of impropriety and redress to those affected by the conduct. She says, I expect the section 7.9 by the end of business today, extension not granted. Correct. So she didn't grant you the extension you requested, correct?
Correct.
3993, Tsepo. Yeah. And then the PP later on that day addresses an email to the CEO, Mr. Vusi Mahlangu, copying Ms. Motsitsi, and she says, this undermining, but I think she meant to say by the executives, has reached a point where I cannot tolerate. The section 7.9 was not sent by Friday. Can the final written warning be served on the executive manager, HASD, and ACO for not also ensuring that as supervisor, that is done per my instruction. I want to see the warning letter by 3 o'clock this afternoon. Do you see that?
Yes, I can see that.
Was that sent to you? Go up.
Mr. Mahlangu did not issue a warning letter as directed by the PP. Instead, he served myself and Ms. Motsitsi with Audi letters.
But later on that day, as per this email, Ms. Motsitsi did forward to you the PP's decision relating to the matter, and she was pleading with you to submit the notice as a matter of urgency, right?
Yes.
And can you recall what happened after that? What you do say in paragraph 123 of your affidavit is that the combination of the immense pressure to produce reports not being heard and threats to one's livelihood made for a very difficult environment to work productively in pursuit of the very targets we were committed to meeting. Are you able to elaborate at all for the committee regarding that kind of stress and pressure?
I think at the time I really felt frustrated because I accepted the additional responsibility even though I was not being remunerated. I was hoping that I am going to assist the organization, and I really felt that, notwithstanding the fact that I had indicated that I needed the support and understanding, instead, I had compromised myself as I suspected. I got frustrated. I was forever working, which I think it was untenable because it's unhealthy for any person to keep on sleeping for 3 hours. And I was even working over the weekends. And it became even more and more difficult to try and keep up. So I was frustrated. I did everything to try and catch up. Nothing was really working. I think the more I tried, it's the more it became even more difficult. I really felt defeated. And I think also whilst it might be seen as Audi letters, I really felt that for me, the decisions were not really, the decisions or directives or instructions, whatever they might be seen as, they were not Audi letters. A decision was already made, because if you say that I must be issued with a warning, it means that you have already decided that I'm guilty. You have already decided that you are imposing a sanction on me, and the sanction is either a final warning or a warning. So I really felt that it's just not worth anything. It doesn't help to keep on explaining, because when we explained, no matter the substantive content of our explanations was not taken into consideration. What was more important was this was due on this date. No matter what challenges you were experiencing, it didn't matter. If I take, for instance, with the bail matter, I went at length to explain the challenges, and the PP responded to me by one-liner, and the Audi letter that was given to me indicated that rather than submitting the notice, I submitted an apology and an explanation that was unacceptable. So it was frustrating, because we were not really, I felt that I was not achieving anything, because no matter how much I explained myself, the explanation would never be acceptable.
Thank you. Just a pause, Edward Mayos. I recognize the hand of Honorable Siabi.
Thanks, Chair, and my apologies. I just wanted to request that she speaks into the mic. Some of the words were unable to get them. Maybe if she speaks directly into the mic.
Okay, thank you, Mr. Siabi. Keep improving, Ms. Mogaladi. Advocate Mayos, thank you.
Thank you, Chair. You say that you, on the 20th of November, you sought legal advice regarding this matter from Mr. Namasisi, right? In paragraph 124 of the affidavit.
Correct.
And I think the email trail where that appears begins from page 4,000. Seppo. Go down. Yeah. What did you seek legal advice about in relation to this matter from Mr. Namasisi on the 20th of November?
Okay, I think the overall challenge about this matter, as I have indicated, was that there was a pending High Court action in the city in the High Court, the North Gauteng High Court. There was an order of court which was a one-page, but the full decision and judgment of the court was not yet issued. And initially, the agreement was that we were going to pen this matter until we have a full judgment, and then we will decide on the way forward on we provide or proceeding with the investigation, or have the issues been ventilated and correctly addressed by the court. Hence, we even went to court to go and upload the documents to the affidavits, just to try and keep ourselves up to date with the discussion. So the difficulty that we were facing was that we still did not have a court, the full judgment. So when I got the full judgment, that was the discussion that I had with Mr. Namasisi to say, now that we have the full judgment, how do we move forward to avoid the situation where we might be accused of having violated the provisions of the Constitution and the Public Protector Act that precludes the Public Protector from investigating court decisions. So our discussions centered around that. So it was mainly me checking that, like the area that I bolded, it was the main focus. And I think according to this email, we even had an earlier meeting and discussion around this matter. So the email was confirmation of some of the discussions that we had. And
the question you posed. One of the questions you posed to him, of course, was whether it would be proper to issue a Section 7(9) letter when you didn't warn implicated parties that you were investigating them, and then confronting them with allegations of their conduct on the fruitless and wasteful expenditure, right?
Yes, it was based on the discussion that we had with Mr. Namasisi, where we said if we were to issue a Section 7(9), maybe we should consider the angle of making findings on the fruitless and wasteful expenditure that was based on the outcome of the court decision that had set aside the contract.
And Mr. Namasisi responded at page 399. Just move up. The bottom. Yes. And he responded, and in essence, he agreed with you, correct?
Yes, correct.
And he said that the implicated parties must be given an opportunity to respond to the allegations in any manner which is expedient in the circumstances, correct?
Correct.
And you had copied the acting COO in these discussions, Ms. Ntoriseng Motsitsi, who also then joined the discussion above that email, correct? Correct. And she also, in essence, said she agreed. She has read through the emails that she'd been copied, and she agrees with you that issues of fruitless and wasteful expenditure can be addressed by the Ppsa and so on, right? Correct. And she suggested that you write a memo to the PP to brief her and advise her that after a thorough analysis of the contents of the file, there was an obligation on the office to give those implicated in the investigation an opportunity to respond, correct? Correct. You then responded to the acting COO at 3998, Seppo. Go up. Yeah. Yeah. Yes, that was your response to Ms. Motsitsi, is that right? Yes, that is correct. And in the second paragraph, you expressed the view that you, as regards writing a memo to the PP, you're not sure at this stage if the memo will help. Why did you have that view? I had that view because I had been explaining myself over and over, and I really felt that the more I explained is the more the explanation is not taken into consideration. And I was really frustrated because we kept on submitting the request, and then we wouldn't really get any support or any form of assistance from the PP in reconsidering the deadlines that were imposed. Instead, it was seen as if we are disrespecting the PP. And also, I was concerned by the earlier email that was sent that the disrespect by the EMs had reached the intolerable level. So if I write again, it would seem that I'm still continuing to disrespect the PP. And you say in the last sentence of that email to the ACOO, you say, as stated and explained in my email, the delay is not aimed at disrespecting or undermining PP. There are challenges that, if not addressed properly, will embarrass us. And I cannot submit an incorrect letter or to PP. That would be malicious compliance, and I cannot do that. What did you mean by the phrase malicious compliance? Okay, malicious compliance, I meant submitting things just for the sake of meeting the deadline, whilst I know that there might be issues. So I did not want to do that. I felt that it would not be proper for me to do that. All right. Can you go to 4003, Tsepo? And so you say in your affidavit at paragraph 125 that Mr. Mahlangu then issued you with this letter on the 20th of November, correct?
Correct.
And this is what you commonly know in your office as an Audi letter relating to the bail matter, right?
Correct.
Go back to the affidavit, please. 3911. Yeah. So you gave that as an example of what you described as the PP's inflexibility and rigidity in relation to the meeting of targets. But in paragraph 126, you also talk about her inflexibility in relation to a traumatic period when you had lost a family member. Do you mind telling the committee about that experience?
Okay. In April 2018, I have a niece who's my brother's daughter, and even though she's my niece, she was raised by my mom since she was 2. So to me, she was more like a little sister. So I received the message on, I think on the 15th late at night, that she was admitted to a hospital and the doctors had to perform surgery overnight. I come from the Northwest, so I was the closest because she was working in Polokwane. I was the closest. So I had to drive there to go and join the other sister who was already at the hospital. She was operated in the evening of Sunday. So I phoned PP and I requested to be excused from work on that Monday. So I drove to Polokwane. In the evening, I sent a further message to the PP detailing the diagnosis and the news that we had received from the doctors. I went at length to explain the condition and also that from what the doctors had told us, there was really very little that they could still do medically. Then on the following morning, PP responded. I think my message was sent to PP late at night after we had consulted with the doctors. And then the following morning, PP responded and sent me a message comforting me. And then she also quoted a scriptural verse. Yes, that is the response from the PP where she says, thanks for the update, Pona. God is a miraculous God, and let's declare healing in your niece and cover her with the blood of Jesus Christ, and you and family keep strong. That was received around 5 to 9. It was just after I updated PP. The following morning, I wrote back. I said, good morning, PP. Thank you for your support. This was on, the PP's message was received on Tuesday, and then the 18th was a Wednesday. I said, good morning, thank you, PP. Thank you for your support. Unfortunately, we lost her yesterday, but we have accepted as a family that it is God's plan and she's resting in eternal peace. It was on a Wednesday. Then PP responded and said, good morning, Pona, condolences to you and family. Indeed, God is a comforter and he will heal the pain of losing such a young soul. God be your strength. The funeral will be this week. That was a question from PP. She said she was a young soul. She was about 34 and it was an emergency that led ultimately to her death. Then the following day on Thursday, the 19th of April, I received this WhatsApp message from PP saying, Bona, can I have all the letters and reports pending? She listed all the matters that she wanted from me at that point in time. The message concluded, I received a follow-up one which says, if I do not get the Como report today, I will have no option but to request the acting CO to initiate disciplinary process. The others, I want them by tomorrow at 14 hours. If nothing is delivered, I will also take action.
And you say you experienced this as the PP's rigidity during a traumatic period in your life.
It's true. Especially that my first message that went to the PP went at length. I disclosed the medical information, the nature of the diagnosis that pointed towards this being something that she had not been sick. I think my last conversation with her was the Friday before that. She was fine. She was driving from a workshop in Gauteng. So in my message, I was explaining to the PP, and I went at length to disclose because I wanted to be open and transparent with the PP so that she can understand what I was going through. And as I had mentioned, although she was my niece, this is someone that I was more like a sister. I was close to her, so I felt that I needed to disclose. And I think also importantly, when I got the PP's message, it was on a Thursday. I was planning to drive back to Polokwane because the funeral was supposed to be that Saturday.
And then in your affidavit, you mention another incident, and you say this related to the late Mr. Abongile Madiba. Can you elaborate on that?
Okay. The late Abongile Madiba. Mr. Madiba was one of the hardworking, diligent, and skilled investigators in this office. I think he joined the office just after me. I think he had over 15 years in the office. He dealt with some of the very difficult and complex matters, and most of his cases withstood judicial scrutiny. And towards the end of 2016, he had completed and issued a report on one of the very difficult matters that we were dealing with at the time. And a few days, if not 2 days after that, he suffered stroke, and he was then partially disabled. He couldn't use the left side of his body. So I really felt that the ongoing demands from the PP and the rigidity towards Madiba, even though it was well known in the organization that Madiba was really struggling with his health. For instance, if he was expected to type reports, he was only using one hand. If he had to page through evidence, there must always be someone. One of the investigators had to sit with him to support him to page the documents. So I really felt that the pressure that was being put on Madiba was insensitive, if anything. And I felt that as someone who had diligently served the office, no sympathy was really, there was no sympathy on the part of the office at the time. And especially when it came to charging Mr. Madiba, he struggled to come to terms. He was really struggling, and probably that's why he couldn't even take the issue of the dismissal. Throughout, as we were going through the suspension, he kept on, his greatest fear was losing his job because he really felt that he would not be able to afford medical attention that he required as a result of his condition. So he passed on, unfortunately, a month after the hearing. And from my interactions with her, even after the dismissal, he passed a very sad and a broken man. And I indicate that, in my view, no support or mercy was shown towards Madiba. He was too sick to defend himself, and for him to go through the hearing, he had to rely on his son for support, because he couldn't really, to prepare the volumes and volumes of evidence, he always needed someone to assist him.
Right. So in the next section of your affidavit, you deal very briefly with other investigations that you were involved in or took part in your acting capacity in GGI. And in relation to the Ppsa investigation, you say that you accompanied the PP and others to a meeting with the president and also dealt with some correspondence and were present at some of the meetings. Was that all your involvement in that investigation?
Yes, in the Ppsa investigation, I accompanied the PP to the meeting with the president, but it was at the early stages of the investigation and I also participated and sat in some of the subpoena hearings with some of the witnesses. But from March onwards, I was no longer actively involved in the matter. The investigators were submitting directly to the PP and were working directly with PP on the Ppsa investigation.
And you also say in the pensions investigation involving Mr. Pillay, you were part of the meeting with Minister Gordon and in early 2019. You mentioned that you'll be able to elaborate on the extent of your involvement in evidence. What is it you want to elaborate on?
On this particular matter, after the investigator drafted the Section 7.9 notice, the COO then, being Ms. Baloyi, convened a meeting, a quality assurance meeting, where as the investigation team, we reviewed the draft Section 7.9 notice with the investigator just to ensure that it was reviewed to ensure quality. So I was part of that meeting and I participated during the discussion of the draft Section 7.9 notice on the Pillay pension matter.
And can you tell the committee about your involvement in the SARS unit investigation?
The SARS unit investigation was handled by Mr. Mataboge, who was the chief investigator that reported to me. He was working on that investigation with Ms. Buyana, who's an investigator in the office. When I joined GGI, this investigation was ongoing. I had scant involvement in this investigation at the beginning. According to my recollection, I was involved on the matter until mid-Feb, towards the end of Feb. As I mentioned, it's one of those that I found that was already being investigated by the team when I joined GGI. And as from the 1st of June, a decision was taken that Mr. Mataboge and his team would no longer be reporting to me. I also,
Yes.
I also attended the meeting with the IGI on the 31st of January. It was a meeting that was convened by the public protector. I was part of the delegation from Ppsa during that meeting.
You also make mention in paragraph 141 that you met with the complainant in this matter in December. Can you tell the committee about that, please?
Yes. After taking over from GGI, I think it was around the end of November, I was approached by the team with a submission. The initial submission was directed to the PP, where it had indicated that the complainant wanted to meet with the team to come and hand over the evidence. but I was informed that the PP was not available and the team was requesting, and they indicated that the PP's PA had informed that I should chair the meeting with the complainant. So I met with the complainant based on that. From my recollection of that meeting, I was with Mr. Mataboge. I tried to locate the recording so that I can speak with certainty around the attendees of that particular meeting. I struggled to get those recordings because we normally record our meetings, but I couldn't get the recordings. And then during that meeting, the complainant sent me a copy of a report, which I think it was a part of the evidence that the complainant indicated he wanted to hand over. And later on, this report was sent to me by email. Later on, when I opened the document, I looked at the first few pages. Based on the heading, I thought it was an SSA report because of the heading. And I never really looked beyond that matter because it was written secret on top. So I never went beyond to read the remainder of the document, and neither also did I disseminate or even print or do anything with a particular report. I just closed it and never got back to it. Actually, I did not even recall because this was some time ago. I was reminded by the evidence leaders that they came across evidence that I have received this particular report, and I went back to my emails and I confirmed that I received the report, but I didn't do anything about it. And I was also included, okay.
Yes, carry on.
I was also included because I was part of the investigation at the initial stages. I was also included in some of the emails following the meeting that we had with the IGI. And also, there was also some exchange of correspondence between the office and the Minister of State Security relating to possession of the classified IGI report. In one of the email, the PP was instructing legal services to draft a letter to the minister disclosing the names of the people as stated in there. And then I think as I was preparing, I noted that there was another email whereby the PP indicated that the name of Mr. Mataboge must be retracted from the name of, it must be deleted from the name of the people who were in possession of that classified IGI report. So it would remain as per that letter that was sent to the minister. It would be everyone in there excluding Mr. Mataboge, according to the later email that was sent out by the PP.
Sorry, the last part, Honorable Gondwe says, didn't hear you.
Okay, I'm saying, following this email, whereas I was preparing, I'm going through some of my emails. I later realized that following this particular email, there was another email from PP where PP was correcting and sending a message to the senior manager, legal services, correcting that Mr. Mataboge was not in possession of the classified report. So I'm saying I'm correcting there and taking out his name from the list because there was a retraction and a correction to take out his name. 19.
Advocate Mayos?
Yes, I'm just waiting for Sepo to put up a PM.
Yeah, the problem is you whispered that, so yes. I don't know what's happening.
Yes. PM 19. You were copied in this email that is dated the 20th of February 2019. Do you see that?
Yes, correct.
Can you explain to the committee what this email arose from?
This email, as I I have stated it arose from the communication between the PP and the Minister of SSA relating to possession of the IGI report. So this was based on the discussion because the minister had responded back to the PP on a letter, or if not subpoena, if I recall correctly, that was issued against the minister. So in there, the PP indicated that legal services can get a legal opinion from senior counsel, and she went on to elaborate there. And relevant to me, there was a question at the bottom of there where PP says, Bona, you have top secret security clearance, right?
This is the email which you, this is the communication you mentioned in paragraph 144 of your affidavit, where you say you understood from this email that other people who had access to the report were Rodney, the chief of staff, PA, and the PP, correct?
Yes, and later on, PP retracted the name of Rodney. Rodney is Mr. Matabo.
So just for the sake of completion, what was your security clearance?
I have top secret security clearance that was granted in 2017.
All right.
It was the second one. The first one that I had was in 2011. It expired, and another one was issued again in 2017.
You mentioned earlier when you were talking about your involvement in the SARS investigation that Mr. Matabucho and Ms. Mvuyana were not really reporting to you about this investigation. Were they reporting to the PP directly, to your knowledge?
Yes, according to my knowledge, they reported to me at the beginning of the investigation, but as the investigation progressed, they were reporting directly to the PP.
Were you ever given the IGI report by the PP?
No.
I'm done. I don't have further questions for this witness, Chair. And Chair, I have kept to the time.
You had no choice. You had no choice. And thank you for keeping to 3 o'clock. Thank you, Advocate Mayosi. It's exactly 3 o'clock as promised.
If Advocate
so the 5 minutes has been kind of gifted to Advocate Mpofu. Thank you. We will now proceed to the next item, which will be the beginning of cross-examination. And I will recognize Advocate Mpofu to start cross-examination. Over to you.
Thank you, Chairperson. Yes, I just want to say to Advocate Mayosi that all of us would keep to the time, Chair, if we were given the kinds of generous times that she gets given. But it's easy to meet a target if it's extended.
No, you get yours too.
I've never had until 3 o'clock.
No, you get yours too. So you will start now.
Okay.
Until 5 o'clock, and you'll continue tomorrow.
Yes, I'll continue tomorrow. Chair, I might even finish earlier than that. I'm just going to place a few issues on the record. Chair, can I do that? Just place a few issues on the record and explain how I'm going to approach the cross-examination. Okay, the first issue is to do with, there's a document which was been sent to us, which is a purported waiver of the confidentiality clause that is contained in the Public Protector Act, which has been issued by the Deputy Public Protector or Acting Public Protector. And we just have a view about that which we want to place on the record. For what it's worth, again, for the usual reasons, so that one day we're not accused of having acquiesced in it. But it might be appropriate. Unfortunately, we had planned to have a discussion on this, myself and Advocate Bauer, over lunch, and then we just didn't get the time, or we forgot. We discussed other things. So I thought maybe, Chair, it might be appropriate for her to explain what that document is, and then I will then place on the record what our objection is. Thank you. That's what we've arranged.
Maybe without putting the letter on the screen, I'll put it into context. There is a provision under the Public Protectors Act, Section 7.2, which deals with investigations by the Public Protector, and it says, notwithstanding anything to the contrary contained in any law, no person shall disclose to any other person the contents of any document in the possession of a member of the Office of the Public Protector, or the record of any evidence given before the Public Protector, the Deputy Public Protector, or person contemplated in subsection 3B during an investigation, unless the Public Protector determines otherwise. Now, there's two ways one can look at it. The most obvious one is that you can't do this during an investigation, but there may be more leeway after that. But that interpretation in itself may be problematic because certain information is given to you, for example, by people who give it to you under the whistleblower provisions, or alternatively people who give it to you anonymously for security reasons, etc. And so there's a proviso in it that says, unless the Public Protector determines otherwise. So irrespective of the interpretation you want to put to the clause prior thereto, I had a look at it. We consulted with a number of employees at the Public Protector's Office who would be bound by this provision, who would have to come and give evidence before the inquiry. There's also the question of privilege that lies within the lies with the incumbent, and I requested that they provide the employees, be it that they come and give evidence for the evidence leaders, or whether they give evidence for the whether they're called by Mr. Mpofu, would then be issued with a waiver in order that they're not at any point accused of transgressing Section 7.2 of the Act. That was all that it was intended to be. There is a caveat that there are ongoing investigations that should be protected, and that we must use our common sense in that regard, and it's not intended to attach that to ongoing investigations. There is also a very narrow line between ongoing litigation, and it shouldn't be abused for that purpose before this inquiry either. And had Advocate Mpofu and I had an opportunity to have that discussion, then I would have certainly indicated to him that it's simply to ensure that within the context of the mandate that those who give evidence before the inquiry neither abuse the powers that they are given very widely under the Act, but that they also not seem to be transgressing the Act. That's the reason why, at my request, this was granted.
Thank you, Chairperson. The only thing we want to place on the record is that we don't accept that the provisions of the Act can simply be quote unquote waived in that fashion. And maybe we'll engage with the evidence leaders as to how that real issue that Advocate Bauer has raised may be better navigated. And again, just for the record, we align ourselves with the interpretation of the section that says the phrase during an investigation clearly does not mean that the prohibition only applies during an investigation. It obviously applies to any information which was acquired during an investigation, whether it's 10 years later, it shouldn't matter. So we agree with that interpretation, and that's exactly why we were worried about the terms of the waiver, because it seems to suggest that it makes a distinction between finalized investigations and ongoing investigations, which is incompetent if you interpret the section broadly, which is what we prefer. So that's the issue, Chair, which I just wanted to place on the record about the so-called waiver. And as I say, we'll try and cooperate with the evidence leaders to deal with that issue, because it will obviously also affect some of our witnesses.
Just before you proceed to whatever next issue you have, so there's a question that both of you are not answering. Why are you raising this thing now? Does this have to do with this witness?
Yes.
So that because I'll have to make a ruling either now or any time that we determine. So both of you are not addressing that.
Okay.
You seem to be, and I'm interested to understand why the issue is raised. So what is your expectation?
Sorry, there's no, I don't think there's an expectation other than the following. Advocate Mpofo had reservations about the waiver. He was kind enough not to interrupt the evidence being led by Advocate Mayosi because he had walked in this morning when we had already started.
I don't get the part that he was kind enough not to interrupt, because what has that to do with the witness that we have?
Sorry, Chair. This witness has a waiver. That's maybe what we should have started off saying to you. And subsequent witnesses who are currently in the employ of the Public Protector's Office, whether they're called by us, whether they're called by Advocate Mpofo, will be afforded a waiver. And there were concerns about the waiver being granted, and Advocate Mpofo wanted to place that on the record, but he didn't regard it as being of such a nature that it warranted interrupting Advocate Mayosi in a direct. So he said to me he would place it on the record before he cross-examined. That's instead of his usual morning placing on the record, he's doing it now instead of then.
Yeah, Chair, if I may assist. Yeah, I think the short answer to your question, why now, is simply because the letter that I've referred to, which comes from the acting public protector, is addressed to this witness, as it was explained. And it's the first one, it's obviously meant to be the first one of its kind, but it's addressed to her. So it applies to this evidence, and that's why we're raising it now.
Okay. I hope members follow, but maybe at this point, as you proceed to other issues and cross-examination, I would indicate that we would apply our mind on the issue, and would make a determination.
Okay.
Yeah,
Thank you.
Then we
Thank
can
you, Chair.
proceed to the other issues.
Thank you very much, Chair. Then the next issue, Chair, is we had an agreement with the evidence leaders, or let me say an arrangement, because for it to be an agreement, it would have to, it's your show, Chair, so I don't think we're allowed to have agreements here. So, and that arrangement was, okay, that arrangement, can I at least finish speaking? Yeah. That arrangement was that this witness was scheduled for a period of 2 days, which is what you've indicated. And the arrangement we had because of the span of this witness's evidence, was that I would do my cross-examination tomorrow. There's a whole set of documents, some of which we have just presented or supplied to the others, to the evidence leaders. And it may or may not evoke one or two questions before we start. I doubt that it will. It's just documents that we want to put on the record. But so that is one of the reasons. But so I'm asking, ordinarily I'd be asking for permission to break now so that I start my cross-examination tomorrow, having covered all those things. But as I indicated over lunch with the evidence leaders, even if you grant me that indulgence, can I ask for another indulgence, which is that I cover some of the ground, some of the high-level issues with the witness, because it may save us a lot of time and also focus the areas that I'm going to deal with tomorrow, rather than wasting time tomorrow with material which might not be necessary. So yes, that's what I wanted to request, Chair.
Yes, definitely we have time now, so we'll allow you to get your partial start. So you're looking for instead of a main meal, you're looking for a starter course.
Yes.
Go for it.
Thank you.
It will save us time. It must save us time.
Certainly will. Thanks, Chair.
Thank you.
I thought Honorable Kondo wanted to raise something.
Just before you proceed, Honorable Kondo.
Chair, you've lost us. We're not entirely sure which letter was being referred to that had been written to Ms. Mogaladi. So if you could just bring us up to speed, because I was completely lost. I don't know if I'm the only one who doesn't know about the letter.
You mean the document they were referring to?
Yes, apparently there's a letter that's been written by the acting public protector to Ms. Mogaladi. So I wanted context around the letter and then,
Okay, let's hear the evidence, leader.
Thank you, Chair. I think I've just asked Advocate Bao to put it up. I think it will make it easier.
And as you will see, the letter is addressed to Ms. Mogaladi. And if you could go down, and the context of the letter is current employees giving evidence before the inquiry. And paragraph 2 is probably the relevant section. As I indicated earlier on, section 7.2 imposes confidentiality requirements with a caveat that says unless the public protector determines otherwise. And so to this end, authority is granted to you in terms of section 7.2 for the disclosure of the contents of any document in possession of a member of the office of the public protector or the record of any evidence given before the public protector, the deputy public protector, or a person contemplated in subsection 3B of the Act, which would be its employees, its investigators, during any finalized investigation that you may be involved in your capacity as the executive manager investigations. That's in Ms. Mogaladi's case. It may be required as material evidence relevant to the full motion before the committee. So what it doesn't contemplate, that says finalized investigations, it doesn't allow them to speak on matters which are currently pending. Public protector reserves the right on a case-by-case basis to review the resolutions in respect of individual matters where such disclosure may adversely affect the vested rights of individuals or institutions, and one could see that from the affidavits that are prepared. And if they have any concerns, they must raise it. And that authority will lapse on the conclusion of these proceedings. Thank you. My apologies, we were looking to short circuit.
Honorable Heron.
Thank you, Chair. It raises other questions about whether the previous witnesses who are currently employed by the public protector, whether they also had a waiver.
The previous witnesses, so Mr. Don't get involved in investigations. They are.
And Mr. Samuel?
Mr. Samuel, Yes, I think, let me qualify that Mr. Samuel requested a waiver and I think it was granted. Whether he had the letter by the time he got it, I'm not entirely sure, but I did have a conversation with him about Mr. Samuel. Yeah, let me double check on that, but I did request the waiver. In fact, the subject came up in the context of Mr. Samuel when I had that conversation. I was reminded by Ms. Mogaladi on Friday as to about the waiver, but I did have a conversation with the PP's office about it in the context of Mr. Samuel, and I was given the assurance that he would have the waiver, but I can't say that I saw the letter. I didn't request it in respect of, Mr. Tabele and Mr. Chialele, because I didn't understand them to be involved in investigations.
Chair, if I may just round off, I think Honorable Heron has raised an important issue, and I think again it will form part of whatever discussions we'll have with the evidence leaders. It's not just Mr. Samuel who was involved in investigations. Definitely not Jalela, but Kekana, Raidani, Ndo, Tabele, some of the previous witnesses that would be covered by Honorable Heron's question. So I think we'll just have to find some legal solution to it, I think, at some stage, just so that we don't run into that legal hurdle.
Yeah, you can't go to you can't go to legal solution when there's no clarity up front. There must be that first, and then we can talk about that.
No, Chair, I agree. All I'm saying is that I'm glad that we're discussing this, because now we've got it even in a wider ambit. But surely we can't discuss it here now and have a nice legal debate here.
Thank you, Advocate Mpofu. Are you done, Advocate Bauer?
I think instead of wasting the committee's time, let me and Advocate Mpofu sort it out. I must say, you're right. I didn't contemplate it in relation to employees who had left, but there may well be a reason to do so, that we do that for their protection as well. But it came up in the context of existing employees involved in investigations, which was the context in which I had raised it. But it must be something that Advocate Mpofu and I can sort out.
Advocate Mpofu, can you please proceed with
Thank you,
cross-examination?
Yes, thank you, Chairperson. Good afternoon, Ms. Mogaladi.
Good afternoon, Advocate Mpofu.
Thank you, ma'am. You had that discussion I had with the chair. I'm going to ask you more detailed questions tomorrow morning, but I just wanted us to cover some high-level areas which might cut down literally some hours from the cross-examination, depending on your answers to those issues. You understand, ma'am?
Yes, I do.
Thank you. All right. Okay, maybe just for context, and at the risk of sounding like a broken record, I've been trying to say that we don't want to turn this committee into the complaints office of the Public Protector South Africa, or a branch of the CCMA, or the Labour Court even. So we try not to get involved in the nitty-gritty of the labour dispute themselves, but only insofar as they may be relevant to the motion. You understand that distinction? You are a legally trained person, correct?
Correct.
Yes. So you understand what I've just said?
I think I do, but you can clarify further so that.
Yes, I can clarify. No, yeah. What I'm saying is that we don't want a situation where the merits or demerits of the legal and labor disputes that feature from witnesses like you to be presented as if this committee's job, for example, is to find who's right, who's wrong on the merits. But by saying that, we're not saying that some of those issues might not be relevant to the motion. So we only deal with them insofar as they are relevant to the motion before this committee. You understand? Without expecting this committee to express a view on the merits. Well, they will if they want, but that's not what they should do. You understand?
Okay. Yes, correct.
Thanks.
Understand,
Yeah.
yes.
Thank you, ma'am. Now, the first issue, therefore, that I want to clarify with you, and this one literally, as I say, might cut down a lot of my cross-examination tomorrow, is this. Do I understand correctly that in respect of your labor matter, which resulted in the suspension and the labor court dispute and all that, your case has only been centered around the question of sanction. In other words, that whole dispute as to whether the public protector is entitled, empowered, call it what you will, to alter the recommendation or finding of the chairperson of the DC, Advocate Kuboni. Do you understand the question?
Can you repeat the question so that I do understand?
Okay. I want to repeat the commentary part because I was just identifying which dispute I was talking about. The real question, crisply put, is, am I correct to assume that your gripe or dispute regarding that issue was only confined to the issue of sanction? In other words, whether the PP was entitled to alter the sanction?
Just to clarify, are you referring to the labor court? The labor
yes,
court
the labor court dispute, the one, that's why I was trying to identify it, the one that resulted in suspension and litigation. Yes.
Yes, the labor court matter that resulted in the judgment of 28 May was focused on the sanction.
Right. And you also, in the build-up, before you even went to the labor court, you made some submissions to the chairperson of the DC regarding the sanction, you know, the normal, what to call it, mitigation of sanction type of evidence. You led such evidence, correct?
Correct.
Right. So you effectively have never taken issue with the finding itself, with the finding of guilt, but you've taken issue with the dismissal, or alleged dismissal, or intended dismissal. Sorry. Correct?
Correct.
Okay. Thank you very much. Okay, that will assist us quite a lot here. All right, because that's I'm avoiding having to get into the whys and wherefores of the actual finding of guilt if the only gripe was about the sanction. All right, thank you, ma'am. Then the next issue that I want us to canvass is just a question of timing. Just for your information, I'm sure you don't know this because you're not as intimate intimately involved with this matter as the people who are directly involved. But just for your information, the motion that is before this committee was passed in around about February 2020, okay?
Mhm.
And the report of the independent panel was issued in February of the following year, February 2021. Yeah, understand that?
Mhm. I follow.
Yes, sure. So again, I just want to situate some of the events that you have testified about would have happened after both the motion and the independent panel report. By that, for example, the sanction, both by the chairperson and the intended sanction, as I call it, by the public protector, would have happened in March 2021, after both of those events. Are we together?
Yes, the sanction happened afterwards, but the disciplinary happened prior to that period.
Okay, good. Yes, the actual DC sitting was before, but the sanction and the labor court litigation and all that happened afterwards, correct?
Correct.
Okay, thank you. All right. And all right, thanks. We'll come back to that again tomorrow. Then on another topic, am I right that the gist of the charges against you for which you were found guilty, which we have now discussed, which is not part of your legal contest, centered around gross negligence, or allegations, let me put it that way, of gross negligence and misconduct with sub-charges, as you said. But that really, that was the gist of what you were being accused of, correct?
Correct.
All right. And so effectively, what you were contesting then is that somebody at your level, which is very, very senior, who is found guilty of gross negligence and misconduct, should not be dismissed, but they must simply be suspended for a couple of months. That's the gist of your case. I know I'm simplifying it, but am I more or less correct that that's what you took to court?
No, you are not correct, Advocate. What we took to court was that the public protector should comply with the internal policy.
Yes, fair enough.
The issue was
So
about
that,
compliance with the policy.
sorry, ma'am. Sorry, I missed
The
that.
issue was about, I'm saying the issue that we took to court was that the public protector should comply with the Ppsa disciplinary code.
Yes, by making sure that what she was intending to do, which was to mete out a dismissal, is not done. Correct?
No, the correct provision in the code and the main source of our dispute was that the public protector appointed an independent chairperson. And in terms of the policy, the chairperson submits a report, a final report to the public protector for implementation. So we were saying to the public protector, you have received a report of the chairperson, implement it and not change it. If you are unhappy with it, as the labor court in the judgment said, then you can take it on review. But you appointed the chairperson and comply with your own internal policy.
Yes, no, ma'am. I think maybe we're not understanding each other. I accept what you're saying. I'm making a different point. That might have been what you were putting in your papers, but your real intention was to stop her from meting out a dismissal. Let me put it this way. And if you can just give me an honest answer to this question. If you know that the chairperson said he was making a recommendation, correct?
I noted that he said he was making a recommendation.
Yeah, all right, he did. Now, the chairperson said you should be on unpaid suspension for 3 months, correct?
Yes, correct.
Yes. So if you give me an answer to this question, if the public protector has said, I'm looking at this, the chairperson says Ms. Mogaladi should be on suspension for 3 months unpaid, but I don't accept this recommendation. I think she should just be on unpaid leave for 1 month. I'm sure you would not have taken that to the Labour Court, correct?
Advocate Mpofu, I think what is key is that the Constitution guarantees everyone fair labor practice. And the gist of the Labour Court matter was to make sure that we are treated fairly. So if the public protector had decided to give us that 1 month, it would have been something that we are considering, but it doesn't take away from the fact that the policy says that the chairperson is submitting the decision for implementation. So if the public protector decided to change that, that would have been the decision. All that we wanted was that be fair, comply with the code.
Okay, sorry, the chair wants to interrupt.
Can I just break your for 10 minutes? We'll take a break.
Okay, sure.
For tea.
Thank you.
We'll take a 10 minutes tea break. Thank you.
Recording stopped.
Thank you, Chairperson. Yes, ma'am. Yeah, I was saying that I think you got the gist of what I was saying. I was saying I accept that technically, at a technical level or at a legal level, what you were challenging was the deviation from the recommendation of the chairperson of the DC. But I was trying to illustrate that your real intention, and I think you've answered part of the question, was what you say was looking for fairness. And I was illustrating to you that if the public protector had said, I'm not accepting this recommendation, I'm actually removing the entire sanction, or I'm reducing it to 1 month instead of 3 months, surely you must, at a logical level, you would not have gone to the Labour Court to challenge her decision. Agreed?
Agreed. Went to the Labour Court because the public protector was seeking an adverse decision that was not in line with the policy.
Ma'am, sorry, I think there's something, it's not, I think that is failing. Can you just repeat that, please?
I am saying we approached the Labour Court because the public protector was, actually the letter was very clear that the public protector has decided to implement that sanction. So we approached the Labour Court because the public protector was taking a decision that was unfair and it was not in line with the disciplinary code.
Okay, I'll try again. Okay. Okay, either you don't understand the question or you don't want to answer it, but I'll just try again. If I accept what you're saying, do you agree with me that had the sanction that she was putting been more lenient, you would not have challenged it just for the principle of it?
Advocating both, my response has been that as an employee, you are concerned about fairness, which is guaranteed to you in terms of the Constitution. So
yes.
If that decision was fair under the circumstances, probably I would not have challenged it. But I think what is clear is that we shouldn't miss the point and the essence of why did we go to the Labour Court. The reason why we went to the Labour Court was to say, fine, you have found us guilty. The policy says you must take the report of the chairperson and it's submitted for final implementation to the public protector. And we wanted the Labour Court to rule and to adjudicate on that particular point to determine whether we were correct or whether the public protector was correct.
And you also say that from a reading of the letter and interpretation of the letter, it sounded as if she had already taken a decision. That's another issue you wanted to clarify with the court, correct?
Correct.
So in the same vein, if she didn't say that, if she said, I've not made any decision at all, I just am contemplating dismissing you and I'm inviting you to make representations why I should not do that, you would not have gone to court?
But that is not the question in this matter, advocating both. The facts on this matter is that there was a letter and we took our decision based on that, on what was presented to us.
Yes. And is there any reason why you did not accept or, accept the invitation of the public protector to make representations?
Because it was not in line with the public protector disciplinary code.
Pardon?
It was not in line with the disciplinary code as approved by the public protector.
Yes, but even that is a representation. You could have said that. You could have just said, that we, exactly what you've just said now, in explaining yourselves, because you are just being given the right to a hearing, an open-ended one. Surely that would have been cheaper than spending money on the labor court.
The main point is that we had to protect our rights as employees, and under the circumstances, we did not agree with the approach that the public protector was taking, and the only way that we can enforce our rights as employees was to approach the labor court on an urgent basis for a ruling, for a court ruling.
Yes.
Because clearly we did not agree with whether the public protector said we did not agree that was in line with the policy. So we couldn't make any submissions, even to say to the public protector, we don't agree with you, because it wouldn't mind to making the submissions. So we approached a forum that would adjudicate on the point that clearly we were disagreeing with the public protector on.
Yes, ma'am. Okay, I'll move on, but again, maybe it's either you don't understand or there's another problem. I'm saying
I do understand.
You do. Okay, let me just unpack it here. I agree with you that you wanted to enforce your rights, and it's a free country. You can enforce your rights in whatever manner you like. All I'm just exploring with you is the following. Remember, when she was giving you the right to make representation, that's also a right, a constitutional right. Understand? Audi is a right in its own right, correct?
And Audi is a right, you are correct. But every action is subject to limitations. And in this instance, the limitation was coming from the disciplinary code. So whether the public protector was entitled to issue that Audi has to be interpreted within the confines of the disciplinary code. It cannot just come from any other prescript, because the disciplinary code was there to regulate the manner in which the employer meted out discipline to employees.
Yes. Okay. Last attempt. I'm saying that if she was giving you a right which you could exercise by simply writing a letter to her, surely at a logical level, that's easier. That's an easier way to exercise that right than exercising the same right by going to a court and paying lawyers and all sorts of things, when you've already been granted a free right, if you like, to make representations. Understand?
No, there was that right. It was illegal. It was not in line with the Public Protector Act. So you cannot call a right, as far as I'm concerned. The Public Protector might have seen it as a right, but as far as we're concerned as an employee, it cannot be a right that is not in line with the policy, especially that it was subjecting us to a process that is unfair.
Okay. Now, you know the Public Protector. Okay, before we even go there, the other theme that I will explore with you tomorrow is something which was raised in this committee on day one by Honorable Hendricks. And I think you are the ideal witness for us to explore that angle. Namely, to what extent, as we hold the Public Protector accountable, to what extent do we also hold the people who reported to her accountable? You accept that constitutionally the Public Protector is accountable to Parliament, but you, and when I say you, I don't mean just you individually, you as the people who report to her and the people who report to you must also be held accountable and maybe responsible for your own actions and misdemeanors, correct?
Correct.
Okay. And it wouldn't be completely fair to visit her with the consequences of your misconduct, for example, correct?
Look, that is a question that is dependent on the circumstances. It's not a straightforward.
Just start again, we missed that.
There is a question that is dependent on the circumstances of each case. More in particular, who was the decision maker? Because within the space in the public protector, each one of us have got different responsibilities. And so it will be dependent on who made the decision under the circumstances.
Yes. No, I understand that. And by saying what I'm saying, I'm not absolving the public protector. The proverbial buck stops with her. I'm simply saying whether, or testing whether people like you who fall into the next layer would be prepared to take your share of the responsibility where the blame lies with you.
Earlier on, when I introduced, I said, if it is clear that I have to be held accountable, I cannot shy away from being held accountable for my conduct, but fairness has to prevail, meaning that you have to take into consideration the entire circumstances that prevailed. And okay, I believe the public protector is also equally afforded that opportunity. The reason why we are here is to afford the public protector that same process of being fairness and determine her accountability under the circumstances. So I am saying there's nothing wrong with me being held accountable, but the overall circumstances that prevailed needs to be taken into consideration.
Okay, maybe.
Some joke, Nick.
Okay.
Okay. Just pause. Just pause. Yeah, just pause. As Mogaladi.
Chairperson.
Speaking to the chair, yeah. Just try again. Come closer to your PC, laptop. We don't want to miss anything you say. We really want to get everything you say. So sometimes there's a break up and we catch you up later. We don't know whether the problem is with you here or here in our system, but we are trying to figure it out.
Can I request a 5-minute break to request our IT to adjust the laptop? During the break, we were requested to reduce the volume, to adjust it to reduce the volume. Can I call him back to readjust
we'll do that. We'll do that, Advocate Mpofu.
Yes, that's fine. I'm only left with a few minutes anyway.
That's fine.
If it will
we'll give you that 4 minutes, 5 minutes break.
Thank you.
Just adjust. It could even be before that. Just attend to it.
Thank you, Chairperson.
Go on, you can, you had a short tea, you can go back and
Recording stopped.
you very much. We proceed. Advocate Mpofu.
Thank you, Chair. Yes. Okay, just to round off a few more of those high-level issues. You said, how long have you been at Ppsa, ma'am?
In December, it will be 22 years. So 21 years. Yes.
Okay, so basically, someone like you and Mr. Ndo would have been some of the most senior and experienced persons who can assist the committee, as I say, with the wider issues, correct?
Yes.
No, he has already done that, and we will also deal with those kinds of aspects with you, which just come from your vast experience in the institution. In fact, you have previously applied for the position of CEO, correct?
In the public protector?
Yes.
No, I don't recall ever applying for the post of CEO.
Oh, because that's what Mr. Ndo told us. Maybe what did you apply for? Maybe he was just mistaking the positions.
I applied for the position of the COO and later withdrew my application.
Okay.
Yes.
Maybe he was making a mistake or I misheard him. Yeah. So you've applied for the position of COO before.
Yes.
Okay. And you were obviously unsuccessful.
No, I withdrew my application.
Or you didn't go as far as the interview?
Yes.
Okay. But yeah, no, I'm just saying that from the point of view of just showing how senior you are in the organization. All right. And do I understand correctly that this acting role of the two divisions was discussed between you and the CEO, Mr. Mahlangu?
Correct.
And you reached an agreement that you would do it, because I see the public protector's letter in respect of that says, it is with pleasure that I approve your appointment. In other words, it was agreed between you and Mr. Mahlangu, and the public protector then approved. Is that your understanding as well?
No, I cannot really say that. Mr. Mahlangu came to me with a letter. So with regards to the approvals, it is a process that the organization can clarify. But my experience is that firstly, before that would be preceded by a proposal to the public protector regarding that decision. So I can only confirm once I have seen that submission. So I cannot confirm that my discussion with or the letter preceded the submission to the public protector.
Yes, no, ma'am. I'm not asking this because I know what happened. I just wanted you to assist us. I'm saying from where I'm sitting, when I read the public protector saying, I hereby approve, then it means that, as you correctly say, there was a proposal put to her. And when you, to my previous question, answered that, yes, you had discussed it with the CEO, then that's what it means. All I'm asking you is whether that discussion with the CEO that you had preceded or succeeded the letter.
I don't know.
You don't. So it's possible that it might have preceded it. In other words, it's possible that he might have discussed it with you and then approached the PP, or the opposite.
I don't know, but it seems unlikely.
Which one? I've just asked you two things. Which one is unlikely?
I'm saying I don't know, but based on the practice in the office, it is unlikely that their submission preceded our discussion. Unless if maybe Mr. Mahlangu, I think only Mr. Mahlangu and the public protector can clarify. But as far as I know, when I had engagements with Mr. Mahlangu, and I'm saying based on my experience in the organization, the letter cannot precede the submission. But only the public protector and Mr. Mahlangu can clarify that sequence.
All right. Good. Then I think the last of these broad topics that I want to oh no, it's not the last one. Let's just go back quickly to the gross negligence and misconduct issue. So I was saying to you, we just got drawn out into the technicalities of the labor case. The essence of your case, and let me tell you why I'm asking you this question. The public protector is charged here with basically the same things that you were charged for, namely gross negligence and misconduct. That's the definition in the rules of parliament, which constitutes an impeachable offense. You may or may not know that, but do you understand it?
No, I cannot comment on that. I haven't really compared between the two documents. I can only comment once I have done a proper comparison.
No, ma'am, I'm not asking you for a comment. I'm telling you something which maybe you don't know. If you can say you knew it before or you only know it now because I'm telling you. I'm not asking you for a comment. I'm saying, do you understand what I'm saying? That the misconduct before this committee is defined in the same way as it was in your case. In other words, it is defined to mean gross negligence or misconduct, which is exactly what you were charged with. Do you understand that similarity? Not to comment.
No, Mr. Mkofu, I note your comment, but I cannot commit myself to something that I don't know, I haven't really looked at. I note your point. I note that as your submission.
No, that's fine. That's fine. Okay.
Except that Advocate Mbovu, that the gross misconduct and would apply to judges in terms of the Constitution. Here it is purely misconduct and incompetence for this committee.
No, that's not true. It is. After this, you must go and check the definition of misconduct in this committee.
You know,
it says gross negligence or misconduct. It actually is grammatically wrong. It says grossly negligent, but that's another story.
Okay, and
no, I'm not talking about
intentional.
Yes, and intentional and so on.
Okay,
but
proceed.
Yeah. Okay, that's fine, ma'am. We'll explore that further tomorrow. The only point, and you may or may not comment if you like, is that no, it's fine. You've already commented on that. The point I was making, that the essence of your case was that in your case, the gross negligence or gross misconduct would be punishable by something other than a dismissal, which is why you went to court. But that's fine. We've already had that debate. Then the other topic, which I want us to, which we will cover again tomorrow, and I think this will probably be the most important section of our discussion tomorrow, centers around your views about the backlog. And I'm just going to test a few propositions with you. And here, I'll use my own previous experience as a CEO, because I suspect I was more of a slave driver than the public protector is cracked up to be. But you accept that in terms of performance management, while the head of the institution or whoever is at the summit of the institution, as you and I have agreed, must be held accountable for the delivery of that institution. Literally, what is really meant is that that person must hold their subordinates accountable to him or her. Do you agree on that as a broad statement? In other words, if you are running an institution with branches all over the show, it doesn't mean that you may never have visited the branch in the Free State or Mpumalanga or whatever, but all those people, their actions, eventually you are going to be held accountable for them. For example, if you had gotten the job as a COO, that's what it would have meant. You would have been responsible for the operations of the public protector everywhere in the country. Correct?
Agreed. Correct.
Right. Good. And so again, it goes to this thing. If something goes wrong, obviously we have to blame the CEO or the public protector or the minister or the president or whatever. But that person is really performing to the cabinet, the EXCO, whatever structure that they lead, correct?
Correct.
And one of their key functions, and that's why we boldly hold them accountable, one of their key functions is to make sure that those other people, whether they're cabinet ministers or whatever, themselves have performance indicators which they must carry out. Otherwise, that person will be correctly blamed for non-delivery themselves, correct?
Correct.
Right. Now,
can I just mention something, Advocate Mpefu?
yes, ma'am.
I am agreeing that you are correct on high level, but I think it's important to point out that whatever, let's say, for instance, if we take the example that you are making, it's got its own limitations and its own confines within which it must be carried out. It cannot just be something that is just blanket to say, let's say, for instance, if you hold me accountable and you set target for me, if we take performance management, it has to comply with certain principles. One of those being that it must be achievable and it must be realistic. So I'm agreeing to that, subject to that high level, on a high level.
Yes.
Yes.
No, absolutely no. We're together then, yeah. No, I accept that qualification. All I was saying is that let's put it this way. You, as the executive manager of GGI or whatever acronym, you accounted to the public protector or to the CEO, correct?
I had the dual reporting. I accounted directly to the COO and the CEO reported to the public protector. So I wouldn't really per se that directly I was accounting to the public protector. I was doing that through the CEO.
Yeah, yes. It's the so-called dotted line responsibility. So your solid line was the CEO, but you had a dotted line to the PP, correct?
I don't agree that there was a dotted line. Everything that I do, I had to report that through the COO. It was a solid line between. The CEO was the one who was reporting to the PP and had a dotted line to the CEO. But in my case, my reporting is It's to the COO.
It's only through the solid line. Okay, fine. No, that's fine. All right.
Hi, Puna. Puna?
Good afternoon. I can hear you.
Yeah, we're just having a glitch, but just hang 10 there.
Okay.
Sure. We're busy reconnecting, but yeah, we'll resume now. Just hold it.
Okay.
Thank you. We're back again. Ms. Mogaladi,
Chairperson,
thank you. Advocate Mbofu, over to you.
What saying cut off hours. In one of your answers to Advocate Mayosi, you confirmed that you had 21 senior people, some of them investigators, others senior investigators, and investigators who were reporting to you. Am I right?
I missed the first part of the question. Can you repeat?
Okay. Now I was saying when you got cut off, all right, I'll speak louder. I was saying when you got cut off, I was asking you the question to confirm an answer you gave to Advocate Mayosi, that at some stage you had about 21 senior people reporting to you, including chief investigators, senior investigators, and investigators. Did I get that right?
Maybe if you can clarify the question, because we pointed out the structures of the two branches. There was a structure for AJSD and the structure for GGI. So if you can clarify for which of the two units. And there was also a breakdown between the different levels in the document.
All right, no, that's fine. When Advocate Mayosi took you to page 3884, right? I told you that's the answer of the people who reported to you. She then put a question to you to say that is a complement of about 21 people plus minus who reported to you, and you said yes. That's all. I was just confirming that answer. Okay.
I don't recall mentioning twins specifically, because that's what I'm saying. Advocate Mayosi asked me two questions. So I think if it can be clear as to between the two.
Yeah, no, it's fine.
I answered the question related. Yes.
Yeah, no, that's fine. You, as I say, you answered it very easily when it was put to you. But it's not even about the number. Forget the number. I'm saying on that structure that is up there, there's an indication that you had a number, more than a dozen people reporting to you, including senior investigators and investigators, assistant investigators. Let's leave out the secretaries for now.
Okay.
On the one side, it's 10. On the other side, it's about 8. So let's say 18 of those senior people, investigators, were reporting to you, correct?
Correct.
Yes.
20 if you add the two chief investigators. But I need to clarify that in terms of the hierarchy, the two chief investigators would be the one that are reporting directly to me, and the levels will go down with the seniors reporting directly to the chief. But I was responsible and accountable for the entire component.
All right, ma'am. Okay. So whatever the number, the point I really wanted to make was when you were being performance managed yourself, the reality is that you have then had a responsibility to manage the performance of those people, 15, 18, whatever the number is. In other words, they themselves, your performance is really being judged by how much you crack the whip on them. In other words, if you don't manage their performance, then obviously your performance will suffer. Correct?
say for the word crack the whip, I would rather say manage their performance,
Yeah.
not crack the whip.
Don't worry about that. Yeah. Call it whatever you want. Manage performance.
Manage, yes,
Agreed?
agreed.
Good. And that's the image I'm trying to paint here. So, and it cascades like that. They also will not be able to account to you with their performance if they don't manage properly the performance of those report to them, and so on and so on. Correct?
Correct.
Right. So what we can do then is it's really the same chain. So if you use that image, so above it, we can just draw another line and put the COO and then put the public protector. That principle will cascade in the same way, right up to the person who delivers the mail. Correct?
Correct.
That's how an organization works. Correct?
Correct.
Thank you. All right. And then you touched on, Chair, I promise this one is really my last one. You touched on some of the issues that you say, and this was very crucial evidence because I don't think we have zoomed in sufficiently on this. You touched on the issues that you say affect something like the backlog. And this is my categorization. You then divided them to those issues that are basically under your control and those that are outside of your control. For example, you spoke about service delivery challenges in government. Those are issues that might affect the backlog, but they are not in your province to control, correct?
Correct.
Yes. And to that list, one can add a whole lot of issues like that. For example, if there's a rise in corruption levels in the state generally, that's also an issue that's not in your control, but ultimately it might affect the backlog or its magnitude, correct?
Yes, in the sense that we might have increased the number of corruption cases.
Complaints. Yes,
Yes.
correct. And also, I think you touched on this one, but I just want to flesh it out. The complexity of the matters. So it's not a matter of just numbers. I think that's what you are trying to say. So I might have 2 investigations and you have 50. But if mine are complex, are more complex, I might take longer to finish mine while you take shorter to finish yours. Am I right? Is that the kind of sentiment you're expressing?
Correct.
Thanks. So, for example, let's take an extreme example. The state capture investigation of the public protector probably started in 2015 or whatever, and it was only finished this year. Include this under commission. But that's because of the complexity of that particular matter. Whereas another matter might take 6 months and so on. That's the kind of distinction you are trying to make. That it's not just a matter of numbers, it's also about complexity, correct?
Correct.
Right. But the one issue which is under your control or which is under the control of the public protector, the one variable that you can control is performance of the staff complement of the office, correct?
Correct.
and you accept that when you manage performance in that way, the classical way to do it is by setting deadlines. I mean, you can, if you have a complex organization, it will never function unless if you have deadlines and time frames, as it is sometimes called.
I agree, subject to my earlier qualification, that they must be realistic and they must be achievable. Chairperson, I can't hear. I don't know if maybe Advocate Mpofu have paused or it's my computer.
Bona, it's Temingosi again. We're just having a challenge on our side. If you can just bear with us for a couple of minutes. Thank you.
Okay. Thank you.
Yes, Temingosi, we keep on getting disconnected from the chamber. Then there's the second time.
We're attending to it, Mr. Mbona.
That's the second time. Just be patient.
Hello, can you hear us, Ms. Mogaladi?
I can hear you, Chairperson.
Thank you. We just have about 20 minutes and then we're done.
Yes.
Advocate Mpofu.
Thank you, Chair. I'm sorry about this, ma'am. I know it's disturbing your flow. It's also disturbing mine. But hopefully tomorrow, when we get to the real thing, we'll have sorted all these technical glitches. Now, I was saying I think you had agreed with me that the one issue that you can control is performance. And so I was saying, for example, in New York.
Can I clarify something, Chair?
Of course.
I agreed that, yes, performance is within my control and target setting is within my control, but they must be achievable and they must be realistic, which is very important.
Yes. No, all these other things must be achievable. I was simply saying that in contrast to the factors that you correctly listed, which are social issues, such as the levels of corruption or the levels of awareness of people about the office of the public protector and so on. But of those variables which would affect the backlog, the one that is within your control, I don't mean you as a person, I mean you as the office. The one that is within your control is performance. Correct?
Correct.
Yes. Oh, yes. Then I was saying, then I think when you got cut off, one of the most important classical, well-known ways in management theory to achieve such performance is by the imposition of deadlines, timeframes, call it what you will. Correct?
Correct, subject to my qualification. I think I have clearly answered that question and indicated that it is subject to those targets being realistic and achievable. It is important that we agree on that qualification, because I cannot take that one part without the qualification that it must be achievable and realistic. Otherwise, if they are not achievable and realistic, then it will not
in every answer. Yes. Okay. In every answer you give, you will assume that the qualification applies. So you don't have to repeat it again. Yeah. I'm saying as a general statement.
I do not agree with the suggestion that I don't have to add the qualification. It's important that I cannot just respond on the one part. It's important that if I feel that the proposition that is presented or the view that is presented to Advocate Mpofu, I agree to it subject to certain qualifications, it's important that I must spell them out.
Yes. No, ma'am. Because again, I think you are misunderstanding me. I'm not saying you must remove your qualification. I'm actually saying you must add it. I'm just saying that we assume that it is there. Yeah, okay. I'm just asking you broad questions. I'm not saying that you must remove it. No, you must put it every time. If you want to repeat it verbally every time, be our guest here. But the point I was simply making is that you must accept that we or at least I understand the qualification, and I take it as a standard. But if you feel like repeating it, that's fine. So the point I'm making, ma'am, is that you can't manage any complex organization without project management. And project management, by definition, involves timeframes. In other words, let's take every investigation in the Public Protector's Office as a project in its own right. Now, that project needs to be achieved. That's how management, that's talking about basic management principles here, not specific things here. That project, for it to be achieved, we must know when it comes. So here's a project, it's called the PU investigation or whatever. And how do we projectize it? We must achieve it in 18 months or 20 months or 100 months, it doesn't matter. But we must have a goal of achieving it and then work backwards as to how we're going to achieve that goal. Isn't that how it works everywhere? Not just in the Public Protector's Office, in any organization that is driven by deliverables.
Correct, but time is not the only factor. All the elements of project management, if we use that as an example, have to be in place. So time is one of those elements that are critical.
Yes, actually, yeah, it is the most critical because it's input and output. The time will just tell you when the product will come. If you're building a house, when are you going to have a house? So whatever happens in between, I agree with you, is important too. But the most critical thing, if I say I want you to build me a house and you say I'm going to do it in 18 months, then at least I can plan when I'm going to move in. That's the kind of thing I'm talking about. So time is important in that sense of framing the project, correct?
No, I don't agree that time is the most critical. It is one of the elements. For instance, you need to have that balance. I cannot just commit. If you say I must build you a house, that you must move into that house within 18 months, Firstly, if I don't have the resources, I would not be able to meet the time. So that is why I'm saying you need to maintain a balance between all the other elements of project management. So you can't just say, I want the house in 18 months when I do not have the resources to build the house.
Yeah, okay. That's my final attempt. I'm saying, ma'am, given all those things, I say to you, you must deliver the investigation report or the house to me. You're 100% right. When you give me that estimate, you must factor all sorts of things. It might the weather, it might rain or whatever. But ultimately, you're going to have a project plan, right?
Correct.
Thank you. All right. Now, just to go to the other theme that we were talking about. So if, for example, you had the report of PEU, that report on our version took something like 4 or 5 years to complete, correct?
Correct.
Yeah. Now, so let's assume the public protector here was being impeached for delivering the PEU report in 5 years instead of 2 or 3. I'm saying, would you, because you were responsible for that report, correct?
Correct.
Yes. And that's really the notion I'm coming towards. So to what extent then, assume there was only one charge here before this committee, it was the PEU report. To what extent, given the fact that you, Ms. Mogaladi, were the person who would have been responsible for the delay of 5 years, and by that I just mean in the collective sense that you were the leader, to what extent must we look to you? Yes, of course, we must look to the public protector because she's the boss, quote unquote. But to what extent must we look to you as the person who has failed to give her the report in 2 years, 3 years, whatever it is?
You need to look at my role objectively, taking into consideration all the circumstances that prevailed. The same way as obviously when it comes to the public protector, the committee or whichever structure that would be looking at the yes. Conduct or the performance of the public protector would look at that matter objectively, taking into consideration a totality of all the circumstances that prevailed.
Correct.
And fairness being one of the key principles that is taken into consideration.
Good. And would fairness involve, if we're now looking to the public protector herself, would fairness also involve looking at all the circumstances, including the fact that the people who were supposed to give her the PEU report failed her? Would that be one of the circumstances?
Look, if you, depending on on how you would want to present that particular PEU, because I'm assuming that to be objective and fair, you can't just say, take that one statement in isolation and say somebody has failed the public protector. You need to drill down and look at the circumstances of that particular case. If the target was that the investigation should have been delivered in 5 years, what precluded that investigation from being delivered in 5 years? So the way I view it is that you can't just decide and say it was Mr. or Mrs. X who failed the public protector without looking objectively at the individual circumstances.
Well, incidentally, why did the PEU report take so long, about 5 years? Wasn't that a bit neglect on your part?
No, the matter was pending in court. I explained when I presented my affidavit. couldn't finalize that matter, and it was a fact that was well known. It was reported during the dashboard meetings that the matter was pending. Some of the issues that related to that investigation was pending in court, so there was no neglect on my part. The full judgment on that matter was issued at the end of October, and in December, the report was finalized.
Right. And finally, on that subject, you accept that one of the pressure points for an institution such as a public protector is the complaints that get received about non-delivery. I'm not talking about the initial complaint of corruption or whatever it is. The complaint by the complainant that I gave you this 5 years ago and I'm still waiting. How can it take 5 years just to check whether somebody stole my cell phone or whatever the complaint is? That is a major part of the pressure points which necessitate this backlog management issue, correct? In other words, it's a desire to deliver to the people, the complainants and the public, correct?
Yes, correct.
All right, thank you. I think we'll then drill down into some of those themes tomorrow. Thank you, ma'am. Thank you, Chairperson.
Thank you.
Thank you, Advocate Mpofu. Thank you, Ms. Mogaladi. We are going to adjourn our meeting for today, and we'll continue tomorrow with you. Thank you very much, and thank you to everybody else who's been with us throughout the day. You well appreciated. I can already see even names from our YouTube team. We've got a team following us. Thank you. The meeting is adjourned.
Thank you,
Recording stopped.